Breaking: Court reserves judgment on Kanu's suit against federal government. Malami, Army and others. Court reserves judgment on Kanu's suit against federal government. Malami, Army and others. To my dear listeners from wherever you are hearing me from, I greet you and stay tuned as I read today's news. Abia State High Court sitting in Umuahia Friday reserved judgment on suit brought before it by the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, challenging his rendition from Kenya, unlawfully detention and subsequent trial by the federal government. Presiding Judge, Justice Benson Anya, after listening to the submissions by counsels to all the parties to the matter, announced a date would be communicated later to them for judgment. Counsels to the various parties had adopted their preliminary objections, written applications and the supporting affidavit before the announcement by the presiding judge. Kanu had, through his special counsel, Mr. Aloy Ejimako, sued the federal government of Nigeria for his extraordinary rendition from Kenya. He demands, among other things, that he be returned to Kenya, where he was abducted, and then to Britain, where he resides, and paid $5 billion for the gross violation of his fundamental human rights. The respondents include the federal government of Nigeria, the Attorney General of the Federation, the Chief of Army Staff, Brigade Commander, 14th Brigade Oafia, the Inspector General of Police, IGP, Commissioner of Police, Abia State, the Director General of the Department of State Security Services, DSS, and the Abia State Director of DSS. In his submissions, Ejimako argued that Kanu's fundamental rights were violated by the federal government and its agencies by abducting him from Kenya back to Nigeria without due process. He argued that the federal government should not benefit from its act of illegality and prayed the court to declare the ongoing detention and trial of Kanu illegal and order his release. But in his submissions, counsels to the federal government and the Attorney General of the Federation, Mr. Simon Enoch, opposed Kanu's application and urged the court to dismiss the suit, arguing that the court lacks jurisdiction over the matter. He argued that Kanu was before now standing trial but allegedly jumped bail and was intercepted in Kenya with the collaborative effort of intelligence agencies and brought back to Nigeria. But when asked to explain how Kanu was brought back to Nigeria, whether or not there was a process of extradition or he was renditioned, which was the issue in contention, the counsel denied that Kanu was renditioned. Counsel to the IGP and the Commissioner of Police, Abia State, Mr. Osage, also opposed Kanu's applications, arguing that the court lacked jurisdiction to entertain the matter. He argued that the application was a breach of court processes and urged the court to strike out the matter. Similarly, counsel to the Chief of Army Staff and the Commander Army 14th Brigade Oafia, Mr. Amos Story, argued that the applications by the applicant cannot be substantiated against the Chief of Army Staff. He further contended that the Chief of Army Staff is not a jurisdictional personality, adding that the Army Council ought to have been joined in the matter for the purpose of paying compensation. Counsel to the Department of State Services, DSS, Mrs. C. Odukwe, also urged the court to dismiss the suit on lack of jurisdiction. But in swift response, counsel to Kanu, who appeared with Patrick Agezi, insisted that Kanu's arrest in Kenya did not follow arrest protocols. Hence, it amounted to kidnapping by the state. He said the suit was not targeted against the Abuja High Court, where Kanu is currently standing trial, but targeted against executive lawlessness. His words: "It is ridiculous for the federal government to claim that Kanu was arrested in Kenya on the orders of Abuja High Court as if Kenya is the 37th state in Nigeria. They pursued my client to Kenya, who was on a visit to Kenya with British passport, and grabbed and renditioned him to Nigeria without due process. Later in an interview, Ejimakor expressed optimism that his client would get justice, arguing that the matter bordered on infringement of his fundamental right, which the respondent could not deny. Counsel to the army, Mr. Tory, also said he was optimistic of a favorable outcome. Meanwhile, the president of Igbo Youth, Igbo Ayaka, who led a delegation of Igbo youth at the court, expressed a sadness over the heavy presence of security agents around the court premises and the adjoining street. He said that the security personnel ought to have been deployed to confront bandits instead of causing unnecessary tension around the city and disrupting free flow of traffic. Igbo Ayaka said that Kanu was fighting against injustice and had the full backing of Igbo youth both home and abroad, and expressed confidence in the court. Contrary to the order of the court, heavily armed combined security personnel had early in the morning barricaded all the routes leading to the premise of the Abia State High Court located at Ikot Ekpenem Road, Umuahia, until around 3:11 p.m. when the court rose and normal traffic flow restored. Human and vehicular movements around the area were hectic as they were being diverted to other roads by the stern-looking but non-hostile security operatives. The situation caused scare in the capital city as motorists and commuters were made to take alternate routes to their destinations. Lawyers, journalists, as well as other litigants and staff of the court assessing the premises were subjected to thorough search. Meanwhile, others prayer by the IPOB leader include a declaration that the military invasion of the applicant's building and premises at Isiama, Afara-Ukwu Ibeku, Abia State on 10th September 2017 by the respondent or their agent is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right to life, dignity of his person, his personal liberty and fair hearing as guaranteed under the pertinent provisions of Chapter 4 of the Constitution of Federal Republic of Nigeria, 1999, and the African Charter on Human and People's Rights, Ratification and Enforcement Act, hereafter the Charter. A declaration that the arrest of the applicant in Kenya by the respondent or their agent without due process of law is arbitrary, illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right against arbitrary arrest, to his personal liberty and to fair hearing as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. To my dear listeners, now I've come to the end of our today's news. Please do drop by the comment section and let us know what your view is all about today's news. Thank you.